Hello everyone, a very good evening to all of you. Welcome to the Officers Adda 24/7, the special session of your BRBL subject in the English medium language. So those candidates who are new in this session, first of all, I would like to say you that daily at, daily at, 10 p.m. at Wednesday, okay? Daily at Wednesday 10 p.m. this class is always go on, so do not forget to see the session. Right now we have just finished module D, the content and the important questions, module B, and today I'm going to discuss a very important topic of module C, that is based on the DRT Act. As you know that in module C, that's contain so many 10 total acts in module C. So right now, first of all, we have to discuss the content and then after we will do the question. So today's topic is, as you can easily see, that the Debt Recovery Tribunal and the Debt Recovery Appellant Tribunal. So what is the basic difference between DRT and DRAT? So we have to discuss this point. Okay, before starting this session, I would like to say you that if you are new in this session, do not forget to subscribe the channel and your new English medium paid batch. Okay, your new English medium paid batch is going to be start from 4th of August. The timing of my subject is 7 p.m. to 8 p.m. So if you are new in this session, do not forget to enroll in the batch. You only have to apply the coupon code, that is July 77, for the 78% discount. Okay, now first of all class, we have to discuss that what exactly the code is. If there is a court, then why there is a need to establish the tribunal? What is the basic difference between the court and the tribunal? So we have to discuss this thing. So now, what is court? As we know that in the court, in the hospital, in the police station, in these three places, nobody want to go. Why? Because once we enter into the hospital, police station and the court now, we know that it will take so much time. It will take so much money. So that's why we just avoid entering into these places. And the court means we have to pay the fees. Court means so much technicalities we have to follow in the court right now. So that's why we just want to avoid the court, and the court have so much burden. So that's why we just establish the tribunal. So what is tribunal? So tribunal is basically the quasi judicial body. What is quasi judicial body? Quasi means half. It is a half judiciary in nature. It is a half quasi, it is a half judiciary body. We cannot say it's a full, it's a half judiciary body. Tribunal are not bound to follow the procedure of a national law, but the court have to bound. In the court, basically judges sit, and the judges are bound to follow the rules and regulations of the national law. Example, for the criminal case, CRPC, Criminal Procedure Code. For civil, that is a CPC. So these are the procedural law that every court have to follow. But if we talk about the tribunal, they are not bound. And whatever the decision that is given by the tribunal, that is also binding on the parties. So this is the basic difference between the court and the tribunal. And we can easily say that not only tribunal, but there are so many alternative method of the court. Just like we have a arbitration, we have a conciliation, we have a mediation, we have a lok adalat, we have a ombudsman. So court is different, but we have a alternative method also. So everyone prefer to go in the alternative method, because in alternative method there is a very simple procedure that we have to follow. So that's why this session is very much important in this one, in which we are going to study the important things. Okay, so now let's start with the, first of all we have to cover the DRT, then after DRAT, what is the basic difference between these two tribunal. And I think the definition tribunal is clear to all of you, and then after we will do the questions that is important from the examination point of view. Okay, and in BRBL subject, as we know that the question type is of case study, one-liner, etc. So now let's start with this tribunal. Okay, so if we just see this one, okay, now see the first one. What exactly this means? What is DRT? So, for the purpose of resolving the issue that is relating to the administrative, tax related disputes, various tribunal has been made. See class, right now we have to discuss only about the DRT. But you know class, except DRT, there are so many tribunal. You know, basically tribunal is made for the particular field. The tribunal is made for the particular field. Suppose DRT is made to recover the debt. Debt means, suppose if the borrower is not able to pay the money to the bank and financial institution, so the bank and the financial institution have a authority to approach to the tribunal. So DRT, that tribunal is made for to recover the debt. And there are so many examples of tribunal class. So for I can say that for the each field na, there is a tribunal. I'm just giving the one example. Suppose NGT. What is NGT? National Green Tribunal. So this tribunal is basically made to just, you know, for the environment. For the environment, that is called NGT. Next, NCLT. What is NCLT? National Company Law Tribunal. So this tribunal is basically made for just, you know, seeing the, the problems of the company. There is industrial tribunal, there is central administrative tribunal. So there are so many tribunals for the each field. And for the banking point of view, DRT has been made for the bank and financial institution. For the bank and financial institution, that's it. Okay, now so we can see that for the administrative, for the tax related dispute, there are various tribunal has been established. So to facilitate the quick collection of the debt, what is this? For the quick collection of the debt, this DRT were established. A very simple concept. So for whom purpose this has been made? So to recover the collection of the debt. That is so simple. For the quick collection of the debt, the DRT has been made. A very simple definition. If we talk about that, what is the objective of this tribunal class? So see, the objective of this tribunal is basically for the fast adjudication and recovery of debt owed to the bank and financial institution. That's a basic thing. You know, in India, there are total 39 DRT. In India, there are total 39 DRT and 5 DRAT. And these 5 DRAT have a jurisdiction over the DRTs. Okay, in the detail one, we will just discuss in the paid class, because in the paid class, we have to finish the all important things. Okay, so this is the definition and the objective. Now see, what is the minimum due amount to file the case in DRT? So it should be class more than 20 lakh rupees. So if the borrower is not able to pay the money, that is 20 lakh and above, so in that case the bank and financial institution can file the case here. So I think this point is clear to all of you. Any doubt class in this 3 point? And if you're having any doubt, so you can please ask in the comment box, because in the comment box the things are there. In the comment box the things are there. Is that okay? So this is basically what this thing. Okay, now let's start with the composition of DRT. If we talk about the composition, so class, in this DRT, it means in every DRT, because there are total 39 DRT. So in every DRT there is a presiding officer. What is this? There is a presiding officer in one DRT. And what is the qualification of presiding officer? The qualification is that should be qualified to work as a district judge. Tenure should be 5 years. He can be served until he just turns 65, and the government can also appoint the recovery officer to assist the presiding officer. A very important concept. This is the composition of DRT. See, is that okay? The composition of DRT. Okay. So I think this concept is clear to all of you, that what exactly the DRT means. Okay. Now let's move toward the DRAT. So first of all, what is DRAT? As we know that class, every, the jurisdiction have a appellant body. Suppose if we are not satisfied with the decision that is given by DRT, so we have an option to file the case in the DRAT, that is a Debt Recovery Appellant Tribunal. We can appeal. So appeal means that the appellant body are well mature than the lower body. So DRAT is the mature one. DRAT is the mature one class. Okay. So in India, there are 5 DRAT. Done. Let's move toward the important key points of DRAT. Okay. If we talk about the important key points, so a person or a business who feel wronged by DRT. Suppose if any bank, any financial institution, or any person feel that the wrong decision is given by the DRT, so he can appeal to the DRAT. And within 30 days, this is very important. Within how many days we have a right to file the case? Within 30 days. And suppose if we want to file the case from DRT to DRAT, so 50% amount we have to pay here. What is this 50% amounts? So DRAT won't consider the appeal until the person pay 50% of the debt that was judged to be owned by DRT. Suppose DRT is saying that you have to pay 25 lakh rupees. The borrower have to pay 25 lakh rupees. Okay. In that case, if you want to appeal, you have to pay first of all 50%, then you can go. And DRAT and DRAT operates by the notion of natural justice. What is natural justice, class? What is natural justice? That they have to follow. DRT and DRAT both have to follow the natural justice. So what exactly the natural justice means? See class. In the natural justice now, we have a two main important quotation. So first of all, we have to discuss two important things, then we will go further. So what are the two basic principles of natural justice? See one by one. The first principle of natural justice is, in the pen tab now, my writing is not too good. Okay, so please don't mind. The first principle is audi ultram partem. What is audi ultram partem? It means hearing both sides. See class, this natural justice principle now the court have to follow, right? But suppose if the matter is come toward the DRT and DRAT, so they also have to follow the principle of natural justice. We are not saying that they are bound by the law, rules and regulations, no, but they have to follow the natural justice, that the nature say that. Suppose if Nikita ma'am go to the court and the case is between Nikita ma'am and Shivam sir, so in that case the court will give opportunity to the Shivam sir also. So after listening the matter of Nikita ma'am and Shivam sir, then only the court will decide the matter. Okay, so this is your audi ultram partem. So odi ultram partem means hearing both sides. After hearing both sides, then only the court have to give the justice. So this is your first principle of natural justice. Okay. Now please listen the second principle. The second principle is I will write it here. And you know this odi ultram partem, it is just a legal language. It is a legal language. The second is namo judex causa sua. Namo judex causa sua. So what it means that no judge can judge his own case. This is very important, and the second principle of natural justice. Second principle of natural justice, that is namo judex causa sua. So what is this? That no judge can be judged in his own case. A very simple concept. Suppose I am the judge. Okay, I have just purchased a one land. I have just purchased a one land, and that land matter just come before me. So in this case, should I handle the case? The answer is no. The nature will say that no, Nikita ma'am, you are not authorized in that case to handle the case, because it is but obvious that you will give the favor in your case. So this is your two natural justice principle that is important. Got it, class? Now, what is the composition of DRT? See, class, if we just talk about the composition now, so in the composition there are amendment also, but in your book na, in your book, in IIBF book, the latest amendment is not written. So that's why we will focus on the previous tenure and the appointment. So here in this case, you can see here, in this case, in DRAT, there are 5 DRAT in our India. Only one member who is referred to the chairman of the appellant tribunal. Chairman should be qualified to be the judge of High Court. What is the qualification? He should be the judge of High Court, member of legal service, held the presiding officer at least for the 3 year. Okay, so it can be this. Tenure is 5 year, and the position until the age of 65. This one. So this is the complete composition of DRAT. That's it. DRAT. Is that okay, class? So this is the complete structure. Now, if we see that, we can approach to the DRT in the two way. The first one is application route. Application means simply, suppose what is written here, the bank and the financial institution can submit the form at the DRT and apply with DRT by recovery of this act. This form should be submitted to DRT. It means a simple way we can, according to this act, you know, this is the act in which about DRAT and DRT it is written. In this recovery of debt due to bank and financial institution, this is the act under which we can easily go to the DRT. The second approach is your surfacey route. The second approach is class your surfacey route. So in the surfacey route, you can see that surfacey enacted in 2002. It is known as by these initials. This act relate to the secured creditor, credit and loan. Secured loans have a lower likelihood of defaulting because borrower has pledged collateral as security for the loan. What is this means? It means suppose secured creditor means we have deposited some security. So suppose if the borrower is not able to pay the money, so we can just sold the property. As a result, in the case of default, suppose if the borrower is not able to pay the money, the creditor seizes the collateral assets to pay off the debt. However, if certain condition exists and the collateral is unable to cover the entire debt and shortfall is seizable, the creditor may pursue the DRT. In that case, suppose if the secured creditor is not able to take the full price from the debtor, so in that case he can apply to the DRT. So there are two ways in which we can just file the case to the this one. So I think this concept is clear to all of you. This is very, very much important. Okay, now let's do the question. First question on the screen. Goods are displayed in a departmental store. Okay, goods are displayed. A find a suitcase at the attractive price and take it to the billing counter. A is the person. The billing clerk informed that the price tag was wrong. It means the shopkeeper is saying that the price tag is wrong and the actual price is very high. A disputes and insists on the clerk to sell the suitcase at the price marked. So tell me whether he can refuse or not. The A option is the store will have to sell the suitcase at the price on the tag. The store can refuse to sell the suitcase at the price on the tag. Okay. C option is the store will be liable if A flies a case in the court, and D is none of the above is correct as per the Indian Contract Act. This is very good question. हाँ जी क्लास बताइए इसका एग्जैक्ट आंसर. This is very important question. So class first case is totally belong to the one concept, and that concept is, I will just write the concept, that is invitation to offer. This is invitation to offer, and invitation to offer is different from the offer, because what offer means that we are offering, suppose Nikita ma'am is offering to sell her car, that is offer. And invitation, the display, the goods are display, that is exactly the example of invitation to offer. So in invitation to offer now, we cannot force the seller to give this item. So that's why in that case, the store will have to sell the suitcase. The store can refuse, exactly, the store can refuse to sell the suitcase at the price on the tag. So for the first one, B is the right answer. For the first one, B is the right answer. Okay, guys? Okay, next question. Okay, before starting this next question, I would just like to highlight a very important thing for you people. See class, this is our CIB ka Mahapack 2.0. What is the best quality of CIB ka Mahapack 2.0? First of all, see the 1 point. The first point is that this CIB Mahapack cover all the CIB batches. Whether we are just bringing the selection batch, target batch, revision batch, case study batch, every batch will cover in the bilingual and in English medium in this CIB ka Mahapack. Suppose if you are not able to see the live classes, then you can see the recorded lectures here 24/7 till 6 months, because right now its validity is 6 months. You can just ask any doubt in the mid of the class. This is very important. Whatever the marathon and mini marathon that we will conduct, it will be included in the CIB ka Mahapack 2.0. You can see here. Okay, and then online mock paper is also there. Online mock paper is also there of each subject plus elective paper also. PDF is also available here. PDF is also available. Whatever we teach in the live class, PDF is there and the ebooks are there. So there are so many things class that is given in your CIB ka Mahapack 2.0. So if you are interested, you can please purchase the batch. CIB ka Mahapack. Okay, now second question. Second question is, normally there is a contract when there is an offer by one person, acceptance by other. Okay, this is the formula of contract. Offer plus acceptance is equal to agreement. However, there are certain situations where contract come effect even without offer acceptance. It means first of all contract is done and then the formalities are going on. So what type of contract it will be called? It will be called general contract, illegal, quasi contract, or invalid contract. What is the right answer? Yes, class. Is that general contract, illegal contract, quasi contract, or invalid contract? This is important one. This is important one. So in that case, the concept is very clear. See, in this is the formula of contract, and this is the where contract is already done without offer acceptance. So this is the example of your quasi contract, because in quasi contract initially we just want to enter into the contract, and later on initially we want to enter into the contract, but later on we have to enter into the contract. So this is the best example to understand the quasi contract. The best example I always used to say, suppose by mistake I just put a luggage in the gate of another people by mistake. The actual address was not that. So in that case, the person to whom I have just put that thing, it is his right to give the things to the right person, or either I will come and put my thing and give it to the right person. So this is the best example to understand the quasi contract. And one example, that is a pizza example, I always used to say that I have just ordered pizza, but by mistake the pizza delivery boy delivered to the my neighbor. My neighbor just ate the pizza. So in that case, that my neighbor have a right. My neighbor have a right. In that case, it is the duty of neighbor to give me my money or this one. So this is your quasi contract. Got it? So whatever question I am asking here now, these questions are very important from the examination point of view. We know that we have a very now less time, August, September, October, November. So we have an exact 4 months. So how to utilize the 4 month? So please attend the English medium batch, which is going to be start from 4th of August. The timing will be 7 p.m. to 8 p.m. So do not forget to attend the class. Okay, the classes is important. Next. The limitation for a promissory note and the bond that is payable in installment is what? 3 years from the date of promissory note, 3 years from the date of first installment due, 3 years from the due date of defaulted installment, and 3 years from the date of first due and the last due. So what is the exact answer of third one? Yes, class. What is limitation period? The limitation period is basically under what time period we have to file the case. So in this question, that's totally belong to the promissory note and bond, and the promissory note is given in the Negotiable Instrument Act. So suppose if the installment is, installment dena hai, so in that case 3 year is but obvious a limitation, but when it will be start? From the date of promissory? No. From date of first installment? From the due date of defaulted installment. So for the third one, class, C will be the right answer. Okay, next. Next question is, that is important one. In which of the following mortgage where mortgager delivered the possession and authorized the mortgagee to retain the possession until the payment of mortgage money and receive the rent and profit occurring from the property? Which type of mortgage it is called? Whether it is simple mortgage, anomalous mortgage, English mortgage, and usufructuary mortgage. So what is the exact answer here? See, in the fourth question, what is mortgage? Mortgage in which we are giving the immovable property as a security. What we are giving? We are giving immovable property as a security to the opposite party, right? To the, suppose if we have taken the 10 lakh loan from the bank, if we have taken 10 lakh loan from the bank, so we are giving the immovable property, suppose land, house, etc., to the bank. So now in that case, what will happen? In this type of mortgage, mortgager is not personally liable. The mortgager is not personally liable, but mortgagee can retain my property for receiving the rent and profit. For the rent and profit. So what it will be called? Simple mortgage, anomalous mortgage, English mortgage, or usufructuary mortgage. So what is the exact answer? Tell me, class. Hanji, class. The answer is very simple. That is usufructuary mortgage, because in this mortgage, this type of thing will be happen. So for the fourth one, D will be the right answer. Okay, next. Where the company undertaken certain activity which does not fall within its object clause. So first of all, object clause. This object clause basically come under C. If we talk about the object clause, so the memorandum of association have a 6 clause: name clause, object clause, liability clause, capital clause, association clause, and registered clause. 6 clauses are there. Object clause means that the company have to follow only that object which is mentioned in the memorandum of association. So suppose if the company is not following that object, so what it will be called? Intravirus, ultravirus, ultravirus, or intravirus. And the extent of liability of the company, and for that thing whether the company is liable or not. So class, if we talk about the fifth one, so for the fifth one, as you can see that the answer will be ultravirus. So the answer can be from B and C. So whether for ultravirus the company is liable, the company is not liable. So the answer will be B. For the fifth one, B will be the right answer, because ultravirus, it means beyond the power. Suppose my limitation is only to teach you the BRBL subject, but I'm teaching also the ABFM subject. So it means that is I'm doing beyond the power. So for the fifth one, B will be the right answer. Okay class, so I hope so you people enjoy the session. And now one question left. What is not true? What is not true for a partnership firm? Not true for a partnership firm. Partnership are registered with the register of firm, not with the partnership deed. Second, registration of partnership firm is not compulsory, it is optional. C, registered firm have certain advantage over unregistered firm. And D, non-registration of firm adversely affect the capacity of partner to carry on the business. So what is the exact answer here? Yes, class. Not true. Partnership are registered with the registrar of firm and not with the partnership deed. Okay. Registration of partnership firm is not compulsory, it is option. It is true. B point is absolutely true. Registered firm have certain advantage over the unregistered firm. True. Non-registration of firm adversely affect the capacity of partner to carry on the business. This is not true. For the sixth one, the right answer will be D will be the right answer, because whether the partnership have done registration or not, that will not affect the this one. No, because doing business is a different thing. Okay class, so that's all for today's class. So guys, this is your English medium batch which is going on. It is already started from 24th of July. So if you are new in this session, do not forget to see the session. In this batch, ABFM subject is going on. In this batch, ABFM subject is going on. So few classes have done. So you can see the recorded class, because in the live batch, you are seeing the live classes, recorded session, ebooks, mock paper, etc. And C class, this is your CIB ka Mahapack 2.0. So what is the basic thing in the CIB ka Mahapack 2.0? So you can easily see here. In this one, you will get the live classes. In this, you can get the live classes of target batch, selection batch, revision batch, etc. You will get the recorded classes. You will get the doubt session, marathon classes, ebooks, PDF, mock paper, elective subject, etc. So everything you are getting in this session. So if you want to enroll in this batch, you only have to apply the coupon code, that is Y391. Sorry, it's a July 77. You only have to apply the coupon code, that is Y July 77. Okay, and this is your GIB SEBI ka Mahapack. It's a bank promotion Mahapack, and this is the Officer Adda Mahapack. In Officer Adda Mahapack, you will get everything of GIB, CIB, bank promotion, and IIBF certification. So guys, if you are new in this session, I'm going to show you the process in which you can just purchase the batch. So for this thing, you have to open the Google Chrome. Okay, just click on Adda 24/7, click on all courses. If you click on all courses now, then you will get GIB CIB. Click on CIB November 2023. See the live classes. English medium, click on English medium. If you want to purchase, click on buy now. Coupon code, it's a July 7.